What can the power of attorney document do for you and your loved one? Well, today I'm going to break that down in very simple terms. So let's talk about what power of attorneys do, how you can use these documents to help your loved ones or friends, and what you need to know for both the person who's involved in the power of attorney as the principal, that's the person being helped, or the agent, the person doing the helping. And then finally, I'm going to break down actually how you get a POA created. There are several ways, but I'm going to show you a very simple one. Power of attorney is a legal document based on local country rules, or in the case of the United States and other similar countries, it might be based on state rules. The power of attorney is essentially meant to assist someone who is incapacitated. So it would be someone in a coma, maybe someone with dementia, or it could be someone who's just traveling and needs someone to look after their finances or their assets while they're away. What are the benefits of a POA? It's about making sure the person asking for the help and the agent is aware of what you want, understands what the principal is asking for, and carries out those wishes according to that POA or power of attorney. The agent can be almost anyone. It can be a friend, it can be a member of the family circle, a child, like in my situation. The good news for the principal and the agent is decisions can be made quickly. You've already discussed it, written it down, had it signed by a lawyer. Both understand the expectations being set. So if financial or medical issues come up and need to be decided quickly, they can be. If you have someone who's incapacitated and they don't have a POA with you, you may have to put them into a guardianship or a conservatorship. If, for instance, you didn't sign a POA with your parent, they've become incapacitated through dementia, but they are able to object to things. You may find that putting them in a home or doing something that actually is in their best interest isn't going to be allowed unless you do one of these other legal actions. It's time-consuming, it's expensive, and it's emotionally draining. A POA is a very simple way of mitigating that drama for the future. The most important thing I'm going to tell you about a POA is if your parent has dementia, which was my case, then you need to make sure you have a POA signed and notarized before they become truly incapacitated. A lawyer or notary will not validate a POA if that person is deemed incapacitated already. You need to do this before they become incapacitated. Now, let me just start by saying sometimes it's really hard to have these conversations with someone who is not incapacitated. They're doing well, they're healthy, your loved one is doing fine. But starting the conversation to say, bad things can happen to all of us. Let's talk about how to create a safety net as you age, and just in case something happens, we're ready. Now, if you want to know about how to start that conversation, check out this video on starting the conversation. I'll also put a link to that video below. I'm going to talk about two types of POAs to keep things simple. And I'm going to take us through kind of a decision tree to show us this. One is a financial POA. The other is a medical POA. So a financial POA allows the agent, that's the child or the friend, helping handle bank accounts, pay bills, file taxes, manage investments, buy and sell property, all of that. This can be durable, which means it continues even after the person is incapacitated, or non-durable, ends if the principal is incapacitated. Often these also can have dates, so that you say, if nothing else happens, this ends on a certain date, or an open-ended date. If it has an end date and the next day after that end date, the person becomes incapacitated or needs help, you can't help them because that contract has an absolute end date. So I suggest on financial, you will go with durable without an end date. And that helps you be ready for whatever happens in the future. You can also update these POAs. You don't have to have a power of attorney in your 60s that's the same as when you're in your 90s. You can then redefine the terms and conditions. Maybe medicine's changed, maybe your financial situation's changed. You can adapt a new document, and then the new document becomes the document used for legal purposes. The next is a medical POA. Medical POA could just be for medical decisions, but it can also include something called the Advanced Healthcare Directive. And this, as the agent, allows you to speak on behalf of the principal if they are incapacitated. You can talk to doctors on their behalf. You can actually sign medical documents for them if they can't sign them. All of this gives control in the hospital so that that person's not just left to the medical community to decide what's true for that person. The other part is this advance directive, and the advance directive is otherwise known as a living will. This can determine a lot of details about quality of life issues. It specifies end of life preferences. Do you want to be on life support? Do you plan to be an organ donor? Do you want to donate your whole body or just organs? All of this can be documented in a living will. And again, most people don't want to think about this, but it will make it so much easier because we all are going to face these points. So it's best to talk about them in advance, sign the document, put it away, and then you don't have to think about it until you need it. And then it's great to have it. And again, like the financial situation, a living will or a POA for medical can be updated. And like a financial situation, it's an instrument that also can have an end date. My lesson learned there is do not put an end date on a medical POA. You can always update it, but don't put an end date on it because the day after that contract ends, you have no authority over that person's assistance that you might need to give to them. The POA gives you all the rights you need to take care of your parent. So now let's talk about what happens when you sign a POA. What does it actually mean to do that? For the principal, that's the person getting the help. They must be mentally competent at the time of signing. This is what I've been talking about. This is what's most important in my book. They can revoke or change the POA at any time. They should choose a trustworthy agent. This shouldn't be your neighbor you met 2 days ago. This is a person who's going to have your life in their hands at some point, and obviously if you do finance, your finances in your hands. It should be someone absolutely trustworthy. And for the agent, they have to act in the best interest of the principal. You need to show that you have that person's goals at heart, not your own. It can't be, I'm going to do everything I can to make sure my inheritance is maximized for me. No, you're acting on behalf of that other person as if you were that other person. You have to keep financial records to avoid a conflict of interest. I did this by keeping an Excel spreadsheet of everything coming out of my own finances to pay for my mother and the costs coming from her. Keeping those kinds of documents can really help you. And that goes to another point that I'll talk about briefly here. And that is that you might put your parent on your taxes as a dependent. If you do that, you have to have impeccable record keeping. And it doesn't take that much to do, but it is an important step. And as I mentioned, you can't use the POA for personal gain, so you cannot use their money. Now the question is, how do you actually create a POA? You can do this online through very simple tools available, and then choose the points that I've already discussed, whether it's durable or a non-durable power of attorney. There are two key players to a POA. One is the principal, that's the person asking for the help, and the other is the agent, that's the person giving the help. The principal needs to choose an agent they trust. If you're the child who's been caring for their parent all these years, that's likely to be you. Decide on the powers to grant. So whether they're limited or general, that could be the ability to care for all things financial, as an example, or only care for the property, or only care for the bank account. Actually, there's tick boxes you can check to say, what's the scope of power that I'm granting? You need to also mention the specific date. When does it start? And in many cases, when will it end? Or that it's open and doesn't have an end date. You will need to sign it as the agent. Your parent will need to sign it as the principal. The notary will need to notarize these signatures and have documentation to prove you are who you say you are and your principal is who they say they are. And then you may, on top of that, need witnesses. These people don't have to be really attached to the situation. They're just agreeing that they were present when all of this signing went down. That's all they're doing. Then, as I mentioned, once you've got that piece of paper, make sure you make copies. Upload it to your phone and have it available. Send an email to yourself with these documents so you can easily forward that to others like banks, doctors, medical insurance companies, etc. And if you're doing the medical version of a POA, it works pretty much the same way. Have the principal choose their agent. Write the living will details out. In these forms, there'll be a section for medical decisions and then living will decisions, end of life decisions. And then you'll have it signed and witnessed. And remember, a POA isn't the same as a will, an actual testament of translation of all their assets. And it's also not a memoriam of what they want when they die. Do they want to be cremated or buried and all those things? So I suggest you might also, at the same time, since you're going to be with a lawyer anyway, make sure they have a simple will at the very least to actually translate where those assets go, because a POA does not do that. And the other part of it is making sure you understand what they want at the end of their life. And this is not in the advance directive. This is about the details of how they want to be cremated or buried, or what they want the memorial to say. This can be either written down, or you can make a simple video that you file away somewhere and you don't need to look at it again until you actually need it. Doing all of this at once is kind of like peeling off the Band-Aid, right? You get all the messy stuff over with, and then you don't have to think about it until you need to think about it again. And if you're in the States, this is basically the information that applies to you. So what happens if your parent's living in the States but then moves to another country? You know, that happens a lot more than you think, because people are looking for low cost, high quality of life, good health insurance locations. And so people are moving out of the United States. What happens when they are living outside the United States? There's going to be different language issues, different notary or legal rules. Using a US created POA in another country, you may need what's considered an apostille. It's kind of an official stamp, and you actually need that official stamped version of the document for the foreign country to agree that it's a legal document in their country. And if in doubt, consult an attorney. If you're working with a US attorney, sometimes they know about some other countries and their local requirements, and if not, you might need to go to that local country and find a lawyer or a notary there. I've got resources for you below. See the links to Getting the Conversation Started video, and see the video on avoiding scammers, because a POA is the best way to protect your parent or loved one from scammers. If you're looking for help and assistance for an aging loved one, then you're in the right place. And I'll see you next time on Aging in Grace.